This rulemaking hearing is called to order. My name is Ed Scudder. I serve as a staff attorney for the Department of Commerce and Insurance Division of Regulatory Boards. Would the agency representatives who are present introduce themselves for the record?
Cody Vest, Executive Director.
My name is Tony Glandorf. I'm the Chief Counsel for Regulatory Boards. Thank you.
It is Tuesday, January 27th, 2015. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204, pardon me, in Room 1B of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on proposed rules the division has made public in order to update the rules of the Tennessee Locksmith licensing program to reflect changes in the locksmith law as well as the locksmith industry. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review for legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table at the front of the room. Only those who have signed in will be permitted to speak. And that sign-in sheet is right here at the podium. The notice of rulemaking hearing, including the entire text of the proposed rules, was published on the Tennessee Administrative Register website on December 8, 2014. And I'd ask that notice be made our first exhibit. Ms. Vest, what additional notice was given to the affected individuals or groups?
The notice was posted on the Locksmith Licensing Program's website, and it was also emailed to anyone who had signed up on the Notify section of the state's website.
As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will now read the substance of the proposed rules into the record. Rule 0780-05-13-.02, the definitions rule, is amended by amending the definition of access control to refer to any barrier or device which prohibits free or unlimited access. The rule also amends the definition of branch office and refers to any physical location that is not the primary place of business at which a locksmith or apprentice conducts activity relative to locksmithing services. The rule also amends the definition of good moral character by adding prima facie evidence that will be considered evidence of poor moral character while deleting the mere use or possession of controlled substances. The rule also amends the definition of instructor by deleting language relative to such individuals' experience, training, or education. The rule also adds the definition for master key system, referring to any keying arrangement that has two or more levels of keying. The rule also amends permanent fixed business location, referring to an office building or dwelling submitted to the Commissioner as the locksmith's principal place of business. The rule also amends the definition for qualifying agent, referring to any person licensed by the Commissioner as a locksmith who is immediately responsible for the operation of a principal office or any branch office. The rule also amends qualifying education, referring to education that is creditable toward the education requirements for initial licensure as a locksmith. And finally, the rule adds the definition for timely renewal, referring to the event when all documentation and fees required for renewal have been received by the Commissioner prior to the expiration of the locksmith license or registration. Rule 0780-05-13-.03, the rule for application for license or registration rule, is amended by the notice deletes the rule in its entirety and substitutes new language that defines the process of applying more concisely and adds requirements that if an applicant discloses any criminal arrests or convictions, they shall provide a written notice and associated documentation in support thereof. New language was added to address a recent statutory amendment requiring all initial locksmith company applicants to be placed on a probationary status. All amendments made to this rule are done so in an effort to protect the public from convicted criminals and to ensure that properly licensed individuals and registered locksmith companies can be located if a complaint arises. Rule 0780-05-13-.04 is the Application Requirements Rule. This rule was amended by removing the effective date clause as it is outdated and no longer of any effect. Rule 0780-05-13-.05 was amended by stating that an application or renewal is not complete until all documentation and fees are paid. It also clarifies that any registrant or licensee who does not submit required fees and documentation within 90 days of the expiration of their current license or registration must reapply. The rule further states that there will be a late fee charged on incomplete renewal applications if they are not filled out completely prior to the expiration of the license or registration. Rule 0780-05-13-.08. This rule is amended by removing a list of items needed to verify employment for experience purposes and instead substitutes the term verifiable so as to broaden what may be considered to verify an applicant's experience. It is also drafted to encourage apprenticeship by clearly stating that this experience may be used toward this requirement as well. Rule 0780-05-13-.09, Continuing Education and Programs Rule, deletes the provision allowing for the carryover of continuing education hours as it was confusing and not clearly supported by the law. The rule as amended more concisely states the continuing education requirements for renewal by licensees and expands acceptable education to include college or university level courses taken by licensees. The rule also more clearly states what is required by an offered course to be accepted by the Commissioner as continuing education. Rule 0780-05-13-.10, Qualifying and Continuing Education Providers Rule, amends the current rule by specifically and concisely stating what is required by a qualifying or continuing education provider in order to have their course approved by the Commissioner and outlining specific acceptable topics. The rule also expands who may qualify as an instructor by deleting sections regarding prior education and substituting instead a process of submitting the proposed course for approval to the Commissioner, which will be reviewed and either approved or denied as acceptable continuing or qualifying education. Rule 0780-05-13-.11, the Civil Penalties Rule, amends the current civil penalties to more concisely state the violations, while increasing the minimum penalty and decreasing the maximum penalty allowed by the rule. 0780-05-13-.12. The proposed rule adds certain requirements of a licensee or registrant regarding submitting information to the Commissioner in a timely manner concerning changes in circumstance relative to their license or locksmith activity. The law more clearly states that no locksmith shall engage in locksmithing without having a locksmith company affiliation. Rule 0780-05-13-.14, the Code of Conduct Rule. This rule is amended by adding language requiring that any vehicle dispatched by a licensed locksmith company be required to conspicuously display the licensed locksmith company identity and license number in accordance with the statute. This rule also adds a requirement that unless otherwise exempt, no licensed locksmith shall provide locksmith services except as an employee, agent, or contractor of a registered locksmith company or as the holder of a company registration. Rule 0780-05-13-.15 is a new rule added to allow locksmiths licensed in good standing in other jurisdictions to be exempt from the initial education and examination requirements in Tennessee if they meet certain certified designations as set by the Associated Locksmiths of America. A letter of good standing from at least one of the jurisdictions in which the locksmith licensed will be required. Are there any comments? Why don't we, Beth, can I get the list and we'll just go down the list? First person to sign in is Mr. Stanley Harrell. Mr. Harrell, if you wouldn't mind sitting right over there, I'm sorry, the microphone won't reach to the podium, so we'll have to ask you to sit right there so that we can hear you.
Morning, sir, and thank you for your time. Tennessee locksmith licensing requirements place an undue and unfair burden on me and hinder the business services I wish to offer. I'm a service-disabled, veteran-owned small business owner, retired 23-year Army veteran, Kentucky resident, sole proprietor, in a border county and community in the Fort Campbell area, wishing to offer what Tennessee describes as locksmith-type services via contract exclusively to federal agencies within 100 miles of my primary business location, which is my home, and exclusively for General Services Administration approved locks, safes, and vault doors of the type required by federal regulations for the security of classified U.S. government information and the security of arms, ammunition, and explosives. Now, my desire to speak to you today is based on an email exchange between me and one of your administrative assistants, in which she made it clear that there were no exclusions nor exceptions in the Tennessee locksmith licensing requirements for contractors working exclusively for federal agencies and then furthermore exclusively on GSA-approved locks, safes, and vault doors designed to serve the purposes I described earlier. While certain so-called exclusions may be in place for military service members or federal employees such as custodians of classified information or armorers, performing as part of their normal duties such as recombinating an electromechanical or a mechanical combination lock, while standing on the physical side of the Tennessee, or the physical Tennessee side of the state line. This understanding is not at all clear when reading the Tennessee State Attorney General's Opinion 10-76, as these personnel are also not specifically excluded or exempt. It is not my intent to offer, now or ever, commercial locksmith services to the Tennessee general public. Federal standards for the neutralization, repair, inspection, and recertification of GSA-approved safes and vault doors already require that these actions be performed by a properly trained GSA technician or inspector. GSA technicians and inspectors must and can only be trained, certified, and licensed at one of two GSA-approved commercial training institutions, Lockmasters or MBA, both in Nicholasville, Kentucky. As I wish to offer only very specific, highly regulated services to very specific customers with unique storage requirements, employing GSA-approved security storage equipment, I believe the Tennessee's locksmith licensing requirements place an undue and unfair burden in the path of my offering such services to federal agencies that may be located in Tennessee. Training, certification, continuing education, or ALOA membership and designation as a certified registered locksmith or other designation, and licensure in unrelated locksmith disciplines only in order to ultimately secure a safe and vault subclass of license is what I believe to be an unnecessary expense and a time-consuming endeavor. I do, however, understand and appreciate other aspects of Tennessee locksmith licensing requirements and would like my own home state to consider such things, such as fingerprint registration, a felony affidavit, a locksmith identification card, background checks, and of course standard business practices such as business licenses and liability insurance. So I respectfully request that you consider rule changes, exemptions, exclusions, or clarifications that specifically address and allow services such as those I've described to be offered in Tennessee by otherwise qualified GSA technicians and inspectors, and clarify the process by which out-of-state companies, including sole proprietorships, may offer such services in this state. Thank you for your time.
Yes, sir. If you have a, is that the substance of what you just told us? Okay. Could we make that an exhibit as a written comment to our transcript here today? Robert Wesson. Morning, sir.
I'd like to thank you for the opportunity. It turns out I was kind of in the wrong venue. I thought this is where I got to voice my opinion on what. Didn't prepare a written, I'm just going to go through your changes.
That's not required at all.
And give you my opinion. Okay, the application for license registration, the probationary period that can be invoked. That seems rather ambiguous and at somebody's discretion of what they may just decide all of a sudden, or they may decide a bond, $1 million bond, a $50,000 bond. There's no perimeters there that I see, and I can see it getting out of control somehow. Which other requirements determined to be reasonably necessary? It depends on your opinion on a lot of things as to what's reasonably necessary. I would like it more defined. Continuing education. Here we go. Added in, you wrote new, 12 hours of education, 2 hours of which shall be dedicated to life safety. I realize we're here to make this meet the law, but where can I state, I can find no meaningful life safety course available to anyone in the East Tennessee area. In my county, I ended up writing it with the fire marshal because nobody had a meaningful one. We can go to Ray's Lock Shop and in Nashville, and then after I took that one, which was great for architects and builders, nothing for locksmiths. And 2 years later, when I tried to renew, I call and I cannot find a meaningful one. Well, go back to Ray's. I talked to Ray. Ray's going to tell me the exact same thing he told me 2 years ago. All I've done is taken a day off from work, paid $85, and wasted a whole day to learn the exact same thing I learned 2 years ago. I believe the state should come up with this curriculum for this course, along with the state fire marshals and NFP 100, which is what we used in Blount County. We went through it, extracted all the portions for locksmiths, put it together, and I believe Mrs. Vest, however, she read it and approved it. That's what I believe needs to be done in that part. The no carryover anymore. I understand you're coming back into compliance with the law, but that was a good thing. When I go to a SAFTA convention, it costs me thousands of dollars in time off from work to go to wherever the venue is, which is generally not in Blount County, and then about $1,200 for 40 hours of continuing education. Now I get to use, what, 10 hours of that? And then because it happened to be towards the end of the licensing period or whatever, I have to throw the rest of it away. That's a very high expense for a sole proprietor. Some of the bigger companies, they got a lot of different venues or ways to do it. I don't. When I'm off from work, I'm off from work. And also, they took out, if you help develop the curriculum, you can no longer get credit towards continuing education. The authorship part, if you author a textbook, is now taken out, which used to be there. And if you authorship a published article, like in the National Locksmith or some of these, you no longer have that to count towards your continuing education hours. Those were good things. I do agree with some of the removal of the instructor qualifications, like associate's degrees and things. That's good. There are some good things in here. I'm just not going over them. And then civil penalties. I believe, if I've read it right, the law says there should be a maximum of $2,500. Why did we put in a minimum? I mean, why are we putting in a minimum? The commissioner may say this is a $50 slap on the hand, don't do it anymore, but when this is changed, it has to be a minimum of $250, which I think is something that's just been added. I cannot find it in the law itself. Then we have the reciprocity. Anyway, I'm nervous here. Clause.
We're all nervous, don't we? Just take
Okay,
your,
everybody.
just take your time, and we'll get.
It
through
seems
this.
like everybody puts all their chips in Aloha, and whatever Aloha says, and that's what we're going to do. It may be because they have the biggest influence and the most money, but they are not the only agency out there that has certification. There's also now the Society of Professional Locksmiths has a certification, and because you don't, if you are at another state that requires licensing similar to Tennessee's, I believe upon looking at that, same as transferring college credits, that should be allowed. If I'm certified, say in California, and it has the same or harder qualifications, I should be able to come to Tennessee and work in a right-to-work state without having to have been a member of ALOA. I personally am not a group joiner, and I do not belong to ALOA. Had I started at 17 or something, I might have been now and been a certified whatever, but I'm not. So I believe they need to do a little more work on that and allow more people to bring their qualifications with them. And all the other stuff I had does not apply in this venue. This is not the right place to say what else I believe should count as continuing education.
It refers to the rules that we're discussing today,
Yeah.
Mr. Wesson.
I don't think it does, so we'll save it for Congress. All right, I appreciate it. Thank you very much.
Any of that to be made as an exhibit to your testimony here today? If you can part with it, I'm not sure we could.
Oh, you can have it. It's just rough notes is all it is. My exhibits were actually the ones for continuing education, which I can't really bring in. Magazines that should be part of continuing education. You're welcome to it if it'll help.
Might help us follow
you're
your
welcome to
your
it.
questions. Yeah, if
We'll
you don't
leave it at
mind.
that. It's your
We'll make it.
decision.
We'll
I-
make that the next numbered exhibit, please.
Yeah, I have it memorized.
Couple of matters of clarification that you talked about. Excuse me. The probationary period is something that's new in the law that can be found at Tennessee Code annotated 62-11-104, number M, as in Mark. And that's something that the legislature passed, and so we're following their lead in that regard. So that's not something that we just came up with. On the carryover, we had some concerns that they statute at Tennessee Code annotated 62-11-111. Number I says that the commissioner shall not grant renewal of a locksmith license until the commissioner has received satisfactory evidence of continuing education completed during the immediately preceding license period. So that's something that we were trying to clean up in the rules. We're just what the legislature's instructed us to do. Sure. Do you need the citation again? Just the. Sure. It says that the commissioner has received satisfactory evidence of continuing education, and then here's the part that I believe is key, completed during the immediately preceding license period. So that suggests to me that if it's completed at the one before, that can't be considered as a carryover. We've allowed, I think it was 4 hours to carry over, and I believe that's why that was done.
May I ask a question for?
Sir, I would ask that if you're gonna continue
Yeah.
to speak, please speak into the microphone because this is being video recorded, and it will not pick up anybody's voice, so that we can have that. And that helps us for our record. Thank you.
If you wouldn't mind identifying yourself. For the record.
My name is Representative Jay Reedy, District 74. The question that I have is on the carryover of continuing education. Within a 2-year period, so if a locksmith receives their renewal with the credits they have now, and with that, in the same, let's say that it's this year, 2015, they've already acquired more hours than they needed, are we saying that next 2 years when they renew, as long as it was within that period, they could get to carry over the 4 hours, or we're totally deleting the 4 hours carryover at all?
Understanding of the way that it's going to work is there's no carryover at all from renewal period to renewal period. Okay. And it's my understanding of how it's going to work.
Right. So if a licensed locksmith had 20 hours in that year, they just lose that. They just need
Yes, sir.
the minimum to renew. Okay.
Yes, sir. He gets the 12, and that's all.
Right. I was just a
Yeah.
little confused on it. It almost sounded like, well, it's as long as you had that class at the same time that you got your renewal, that those hours could be carried over, but not something that you had 4 years ago, for an example. So we're just trying to clean it all up, saying there's no carryover period.
My understanding of how it's going to work.
Okay. Thank you.
Thank you. Ron Harrison.
Ron Harrison, Harrison's Lock, Inc., out of Lebanon, Tennessee. Is this a place I can ask some questions also?
Pretty
About
much,
the
you know,
changes?
we need to focus on the rules.
About the changes in the rules. One question is access control. If my understanding is correct, we're listing all these things here about access control, but if the alarm industry is still the way it used to be, and I think it is, if you have a contractor's license in Tennessee and you don't advertise you're doing in direct sales of alarm systems and access control, you can do access control and that type of stuff. Is that not correct?
I don't believe I
What
understood
kind of
you. I'm
contract, are
sorry.
you talking about a general contractor's
Well,
license?
it used
or,
to be even if you were a plumber, if you were a contractor in Tennessee, in the percentage of alarm business you did was so minimal and you didn't offer direct sales in alarm industry, you were exempt from the alarm licensing.
You mean if you ask for the exclusion?
Yes.
50% of your business.
But there is that
Is
still.
that-
Yeah, there's still that
Yes,
So
sir.
that means most locksmiths don't realize it, but they can do, as long as they don't have direct sales and advertise and do monitoring.
They still have to file for the exclusion through the alarm board.
It's not just something you can go off on your own and do. You have to submit documentation showing that it is, in fact, less than 50% of your business. And you get a letter program saying you got an exemption.
And if let me ask the administrative assistant there. Beth, don't we have in the clause in the alarm board that for the locksmith as well?
The law only authorizes certain electrical, HVAC, and mechanical contractors to be eligible for that exclusion. And the rules clarify which electrical contractors can file. There's nothing in the law that would authorize a locksmith company to be eligible to file for that exclusion, or a general contractor.
So they changed that.
About 10 years ago.
Mind identifying yourself for the record.
I'm sorry, my name is Beth Bell. I'm an administrative assistant for the program. Thank you.
Under branch office, I think probably very few shops in Tennessee have branch offices. I'm one of the few that have offices, and you know, we got our hands slapped because we didn't notify the state that we'd opened up an office in Dixon. That may be the only time it's ever happened in Tennessee. I don't know, but also have, and I think this is clear, but I want to make sure. I have my main office is in a locksmithing office is in a shopping center. We own several units in that shopping center that we do administration work in. I don't have signs above those doors. I don't want people walking in there. You know, that is excluded in this, correct?
Yes, sir, as long as you don't have advertising or anything that indicates to the public that this is a place of business, like if you got a storage unit or a administrative office, that's not considered a branch office under that rule.
Okay. Under qualifying agent, are we saying every location like the alarm industry has to have a qualifying agent now?
I'm going to say no.
Okay.
Way it is designed now, there is a qualifying agent. That's the person who has to qualify the company license, which probably was you. You're going to open an office in Knoxville. It has to have a licensed locksmith. You would send a licensed locksmith, but you would still be the qualifying agent for that license, for that
Qualifying
office.
agent can be at different locations.
Yes, so you could be at one location and have 6 different offices, and you still be the qualifying agent.
One thing I would like to say about the continuing education, I would think it would be good if they did
Mr. Mike Griffin. Okay, great.
Your concerns have been addressed? All right, thank you.
I know you said that if you wanted to talk, that you had to sign up, but is there anyone else that didn't get their name on the list but would still like to make a comment?
My name is Melissa Bass, and I represent the Tennessee Organization of Locksmith. And I want to commend y'all and your staff for the rules that you've come forward and having a public forum and notifying us all so that we could be here to address it. And I basically just wanted to go on record that a lot of the issues that are coming up on these rules were just simply statutes that you all are following up with. And I think some of the folks in the audience, if we could, get a little bit more organized in our group statewide, some of these issues have already been addressed for the last 3 to 5 years, and we're just following up, trying to get our rulemaking caught up with what the state legislature has already done. So I really want to commend y'all's work. I think you all did a great job on the rules, and it's a great start in the first process of them. So thank you again.
To Tennessee Code annotated sections 45401 through 45402. Prior to initiating the rulemaking process, all agencies must conduct a review of whether a proposed rule or regular rule affects small businesses. Each agency must employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small business. The agency shall consider each of the following methods for reducing the impact of proposed rules on small businesses while remaining consistent with health, safety, and well-being. First factor is the extent to which the rule may overlap, duplicate, or conflict with the federal, state, and local government rules. The agency determined that the Commissioner for the Department of Commerce and Insurance is the sole regulatory agency for locksmith licensing in this state. There is no overlap, duplication, or conflict with federal authority. The next factor is the clarity, conciseness, and lack of ambiguity in the rule. The agency determined that the rules are clear in purpose and intended execution. The rules are not open to different interpretations. The third factor is the establishment of flexible compliance and reporting requirements for small businesses. The department does not propose to alter current reporting methods. The fourth factor is the establishment of friendly schedules or deadlines for compliance and reporting requirements for small businesses. The agency determined that deadlines for compliance and or reporting are based on the existing license renewal cycle for all licensees. The fifth factor is the consolidation or simplification of compliance or reporting requirements for small businesses. The agency determined that compliance and reporting requirements are simple and are no more complex than those currently existing for other similar licensed professions. The sixth factor is the establishment of performance standards for small businesses as opposed to design or operational standards required in the proposed rule. The agency determined that the department does not propose to amend the current performance standards for small locksmith businesses. And finally, the seventh factor is the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. And the agency determined that there are no known barriers stifling entrepreneurial activity, curbing innovation, or increasing costs. The agency adopted the regulatory flexibility analysis, and I'd like to make that the next numbered exhibit in our transcript. Pursuant to Tennessee Code Annotated Sections 45-220 and 45228, any rule proposed to be promulgated shall state in a simple declarative sentence, without additional comments on the merits of the policy or the rules or regulation, whether the rule or regulation may have a projected impact on local government. And the agency determined that these proposed rules would have no projected impact on local governments. And the agency has adopted the impact on local government statement, and I would ask that be the next numbered exhibit to the transcript. Gentlemen, that concludes our rulemaking hearing, and we appreciate you all being here today and participating in the rulemaking hearing. Adjourned.